Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Welcome to Empowering Plans. This is Rebekah and McGuire-Dye, and I am proud to be the Vice President of Customer Success with the FIA Group. Here with me today is Lisa Hill. I'm going to turn it over to her to introduce herself.
Hi, I'm Lisa Hill, and I am a senior subrogation attorney here at FIA. I have been in the subrogation business for about 20 years. I've worked alongside with Rebekah for most of those 20 years, so we have a pretty good history in the background of what's going to affect their subrogation and reimbursement recoveries.
Now, Lisa, I noticed that you went ahead and told them our secret, and that was that we've worked together for, we talked about it earlier, it's right at over about 22 years that Lisa and I have been in this cost containment industry. Both of us are attorneys by degree, focusing efforts on cost containment for health plans, which is what we're here to talk to you about today.
Well, today we have something that's hot off the presses. The Supreme Court of the United States has agreed to hear a case based on Medicaid, and it kind of derives itself from the Ahlborn decision and whether or not that we might get continuing guidance on how Ahlborn plays out. And this case comes out of Florida. It is Gallardo v. Marsteller, and it involves whether or not Medicaid can collect from any medicals that a beneficiary collects, meaning any future or past medicals, or if they are limited to collecting just those things that are allocated to past medicals. And this is becoming highly relevant in that we have decisions across the country that are differing as to whether or not Ahlborn breaks down into just past medicals or if it includes future medicals. We have differing decisions coming out of state courts and district courts, and they're kind of conflicting with each other. And in this particular instance, we have a direct conflict between what the Florida State Supreme Court has said and what the 11th Circuit Court has said is the outcome. And as you and I were talking earlier, Rebekah, today you were mentioning how the Medicaid stats have grown recently. This is going to be a really important topic.
Absolutely. We had discussed, and I want to share with our listeners, that a survey that was put out, I'm going to, not say the name to protect the innocent, but that is one of the top 10 health plans in our country, has published a survey that gives some fantastic data. They've been able to do a 29-state survey, and have published the same, that the numbers are staggering, and that is, if we look back to March of 2019 to March of 2020, there was less than a 1% growth in Medicaid membership in our country. Now, that less than 1% has changed. And when we look to March of 2020 to March of this year, 2021, there has been an average growth of 20% in Medicaid membership. That's over 10 million new covered Medicaid lives. On one end of that reporting spectrum is the state of Tennessee that had a little bit less than 10% increase. The other end is the state of Nevada, 37% enrollment increase in the Medicaid program. Those numbers are staggering. My home state of Kentucky, we've increased it 25%. Think, well, what does this really have to do with cost containment? When you look at the big picture, it's fair to say that an organization, we're going to put a figure and say, well, every life that you cover, you should be able to save X amount of money through subrogation and reimbursement, which is part of the decision that we've been talking about. And that is, what amounts can you be reimbursed from? We're not talking about a little bit of money. If we think that if just a random kind of industry average, $10 a life is what a program could expect to recover on subrogation. And just so everybody knows, that's not the FIA number. This is just a random $10 number that kind of hits towards the middle of where a lot of people are. But that would be $200 million
Wow.
in increase if it were $20. If we said $20 a life, that's $200 million. Let's par that way down to my $10 example. $100 million in recoveries are what we're talking about with the increase in just these 29 states. So how is Medicaid going to be sure to be funded and to get this money back?
Exactly. And that's part of what we're discussing today, is that in this case, particularly in subrogation, since Ahlborn's come down, and for those listeners who aren't necessarily as familiar with Ahlborn as we might be, when Ahlborn was decided, it decided that Medicaid could only seek reimbursement from a portion of the settlement that represents medical expenses from a third party. And that came down in 2006. And at the time, it was a hit to the subrogation world because it sort of limited what we could recover from. But then in 2013, there was another case that came out, WOS, and that regarded a state statute that automatically assigned 1/3 of any settlement to medical expenses. And the case came about that said, well, that statute conflicts with the federal anti-lien provisions in Medicaid. And because what might happen is part of that 1/3 might be related to something other than medical expenses. And so you're then attaching property, which is prohibited with the anti-federal lien statute. So WOS came out and said, so any state statute that comes out that permits the state to take more than the portion of recovery designated for medical expenses is unenforceable. So that sort of cut down things a little bit further. But then in 2017, amendments to the Social Security Act were passed that strengthened third-party recovery rights for Medicaid, as it allowed recovery from any payment received from a third party. So that was regardless of whether or not it was related to medicals or anything else. Then in 2018, President Trump came along and signed the Bipartisan Act of 2018 that retroactively repealed those amendments. And so we were once again back to what we were allowed to collect under Ahlborn. Now, the case that we're talking about today is Gallardo. And in this instance, a young girl was hit after she exited her bus. The case was settled, and Medicaid requested reimbursement for the benefits that they had paid. And this case now came up through the federal courts. I'll just give you that piece of information there. And the issue is that there's a Florida statute that applies a formula to determine what portion of recovery is allocated to medical expenses. Now, some people might say, hold on, this sounds like WOS with a North Carolina statute that said 1/3 is allocated and that was preempted. Well, in this instance, Florida allows the beneficiaries then to challenge that allocation. And so that's what makes it different, is that it's not an automatic allocation. It's sort of a general rule that can then be heard and decided in court what the true allocation is. And it was during this process in Gallardo that the Florida State Supreme Court came through and heard another case, which is called Giraldo. Very similar, but it's Giraldo rather than the Gallardo of the federal court. And the Florida Supreme Court came down and said that the Medicaid Act preempts the Florida statute and limits the state to seeking reimbursement from settlement amounts only allocated to past medicals. Well, the 11th Circuit, after hearing about that, and in Gallardo, just decided that they thought Giraldo was incorrectly decided, and they have decided that the Medicaid Act does not preclude the state from seeking reimbursement of its past medical expenses from future medical allocations. So now we have conflicting law in Florida. We have the state Supreme Court and the 11th Circuit Court. And so they have submitted this to the United States Supreme Court for hearing, which has been accepted. Because part of their argument is now with this conflicting state law in Florida, you are going to promote forum shopping and a race to the courthouse. Because if you're going to get the better benefit from the federal courthouse, that's where you're going to file your suit, or if the state courthouse, and whoever gets there first and gets the ruling first wins. And so that would treat identical beneficiaries differently under the law. So that's what's being decided here. And it's going to be an interesting hearing to figure out exactly where they're going to come down on the interpretations and the sort of statutory rules of construction, because those are going to be becoming important in determining exactly what was the intention of the statute. Because the other issue is that no matter which way the court decides on this, that means there are going to be some states out there that are inadvertently in conflict with the Medicaid statutes. So we might have some states having to run around and do some fast law changing in order to now be in compliance with the Medicaid statutes. Because, for example, I believe it's Massachusetts has their third-party recovery statutes for Medicaid say that it can assert its claim from any allocation for future medical expenses. So if the court comes down and holds that, no, you can't do that, it's only from past medical expenses, Massachusetts is going to have to go in and change. Otherwise, they're not in compliance with Medicaid. So the results of this decision are going to create waves, not just in the courtroom, but probably in the legislature as well.
Lisa, that all makes good sense in a way, and that is because whenever we have conflicting laws, I think that most listeners will understand that the United States Supreme Court does not grant review to but a small percentage of cases that come their way. And this one has so many layers of conflicts between federal and state courts that it really almost has to be something that the highest court in the land rules on. You spoke to us a little bit about how we got here, the Ahlborn history, and I wanted to get your thoughts on, the Was case back in 2013 revolved around that, I believe it was a North Carolina statute that automatically assigned a third of a settlement to medical expenses. Then we had the 2017 Social Security Amendment that gave a little bit more. It allowed us to recover from any payment, and that any payment is the language that was in that. So any payment. So we're looking at some place was a third. Now we're saying any payment. And now we're limiting amounts to the portions of the specific allocated to medical expenses in 2018. So in 2021, I don't know what the right answer is, but I know that it needs to be a consistent answer for the plans. This rash of growth in Medicaid recipients and Medicaid membership is not new. Some people may recall that back in 2009, when there was a recession, Medicaid spending and enrollment grew. It was back in at 7, 8, kind of ended in 2009. Medicaid spending and membership continued to grow into 2010. Nothing would tell us as a professional body that this trend won't hold the same and that Medicaid recipients will not continue to grow and the use of that program won't continue to grow on through 2021, even though the pandemic is over. And I think I failed to mention that earlier in that when I talked about all the increase, what happened? I think everybody has lived through this, so understands that, the difference in March of 2019 and March of 2020 was a global pandemic, which is much more serious than a financial recession. But now we've had this pandemic and we're seeing the Medicaid numbers increase and increase. We talked about this could be $100 to $200 million. The court's decision could really impact and move that needle on funding for this program. Do you have any thoughts as to where you think the court will come down on this?
Well, before I get to that, you were talking about, they could really move the needle. I mean, and when we're even talking about just the difference between an allocation from past medicals or from all medicals, in this case, Gallardo alone, we're talking about a difference of Medicaid being able to recover about $300,000 versus $35,000. I mean, that's just one case alone. And, so this could have a really huge financial impact if it allows us to recover from all medicals rather than just those allocated to past medicals. I don't know where the court is going to come down on this one. We have 3 fairly new justices that I don't have a firm grasp on which way that they might lean on this. But I guess if I had to guess, my guess is that they're going to come back and stick with Ahlborn and say they're probably going to restrict it to only past medicals. But I don't have anything to completely back that up. As I said, that it's just a feeling on the basis of reading some of the other opinions from the other cases across the country dealing with this topic. It's all going to come down to, I think, the new justices. I think we're going to get to see their licks on this one and see how they're going to follow statutory construction and interpretation and how much emphasis they place on the spirit versus the exact wording.
Yes, that makes really good sense in that it's going to be one of these things. We're going to rely on the interpretation of the Supreme Court to let us know. There is, in American jurisprudence, there is a strong sense that we want to do what is right as a people and as a body. So is it right that some party, in this case, it happens to be governmental funding, pays medical bills But then when there are dollars to allocate for an injury, that those medical bills are not repaid. That weighs on one side of the justice scale, but yet on the other, there is the injured party who is perhaps, had a grave life-altering injury. So shouldn't they receive some money? So really, I totally agree with you. It just depends on how it is interpreted. And my hope would be that it is equitable. The case at hand that we've been discussing, to me, it seemed there could have been some issues with how the settlement funds were allocated. Did you read that in there as well? Or am I just...
Well, yeah. Well, that's that's the rub here. I believe that the total settlement offer on it was $800,000.
Yes.
And that's why under the Florida statute, it has, I can't remember the exact allocation under the Florida statute, but there is a formula that they use to determine, quote unquote, how much is allocated towards medical. And then the beneficiary gets to come in and challenge that number if they feel that it's incorrect. And I believe based on the formula that they were saying that Medicaid was entitled to somewhere around $350,000. And they came in and said, no, based on those numbers, we don't think that that's proper. Here's the proper allocation because it's based just on past medicals and other issues. And we think it's only $35,000. And the court was in the middle of determining how they wanted to allocate it, which one that they felt was correct, when Geraldo came down. And it was at that point that the beneficiary said, well, okay, hey, look, we don't have to make this decision. Geraldo already made it for you. And the 11th Circuit said, nope, we're still going to decide it because we think that they were wrong. Yeah, that's basically what happened on that end.
Yeah, which it's very interesting. We don't know the outcome. We know, which we've discussed here in this afternoon's podcast, regarding how we got here, why it's important that we get an answer. And I guess at this point, all we can do is hurry up and wait.
Exactly. It's going to be exciting when it comes out because it could mean some big changes money-wise for Medicaid. We'll have an answer one way or the other.
And when is the court hearing this?
I don't know. They had just decided to hear it right at the end of their summer term, so probably not for a while.
I hadn't seen a date, and I thought, maybe you're more cutting edge than me, that you had known. So I guess our listeners will just kind of have to do the same thing we are, and that is hurry up and wait for the decision, but understanding that it is important and it could drastically impact our cost containment industry.
Absolutely. Fully agree.
Well, as always, Lisa, it's been a pleasure with you today, and thank you for your time, and thanks to the listeners.
And thank you, Rebekah. It was always a pleasure speaking with you, and thanks everybody for listening. We'll keep you posted.
Have a great day.
Bye.